Hello and welcome back to the channel. Thank you for joining me in another of my wonderful interviews. Have you ever been to court and have you wondered if you can get in front of a jury so that the jury listens to everything that you, perhaps as the defendant, has to say for the case, and then the jury makes up the decision? It's something called trial by jury, which it seems is very difficult to get because they seem to want to either do things in a magistrate's court or they want to do it by jury trial, which is a different thing. Now, you may have heard and seen the lovely Dean from Buxton come on, and he's often said, we need to get trial by juries. Well, Dean very kindly recommended me to a gentleman who's going to join us in a second, who has managed to have exactly that, a trial by jury, for what he says is a regulatory offence. So this is going to be really interesting. I'm very much looking forward. So today my guest is Edward Ottely, and he joins me now. Edward, it's very lovely to have you on the show.
Thank you, Richard. Very happy to be here. Thank you.
Now, this is really interesting because we've been talking about trial by juries for some time, and we've heard how difficult it is to get there. You can't just sort of say, oh, okay, I'll go to court. Can I have a trial by jury? And that's it. It seems very complicated and something they don't want to happen. So I'm going to, if I may, ask you to tell us your story. What was the offence, crime, whatever it is, and how did you manage to get to court and what happened?
Yes, well, it was a regulatory offence, as you said, Richard, against my company, property management company, and myself as a director of the company. Now, it was a fire safety offence brought as a private prosecution by the fire service. And of course, they're all employed by the county council, as the court would be. So it's important in order to get a fair trial in this case, because there'd be no oversight of the case as well. It's not as if the Crown Prosecution Service had had a look at it. It's a private prosecution, a bit like the post office one, which was a
Right.
private prosecution. And so they're bringing you before the courts, got a summons, and you therefore got to decide, am I going down the legal route, in other words, with a solicitor, and they'll recommend a barrister. And that's, first of all, not really understanding trial by jury or anything other than legal. I went down that route with a solicitor and a barrister, ready for the magistrate's court, which is always the first port of call, if that's
Right.
the right word. And having sat down with them, told them the story with all the mitigating circumstances, because this was over a building with cladding on it. So it's hardly as if it's a building that's, one where there's a dangerous staircase or something. There are hundreds, possibly thousands of these buildings of different kinds across the country. So one has to put this in perspective and also the changing regulatory framework that's been going on. We've all heard about these buildings. This particular building, by the way, just to put people's mind at rest, is 4 to 5 stories, hardly a Grenville Tower,
Yes.
which was 40 or 50 stories. So, well, a lot of stories anyway. So there we are, and telling our story, which you would do to your solicitor, then telling your story to the barrister. And they tend to paint it unexpectedly quite negatively, and say, well, this is a regulatory offence, very hard to defend. Did you have a suitable and sufficient fire risk assessment with cladding? Very hard to defend. Did you do this? Did you do that? And before you know it, also the bill is stacking up with the solicitor. In my case, it was £4,000 before we got to the magistrates.
Wow.
The barrister is charging 5 to 6,000. So having also had a bit of experience in the past with a solicitor and a barrister, thought, hang on a minute, we seem to be coming down the same route. And luckily, at this stage of them really painting it black, so you're not feeling good. Really, you need a team behind you who's a bit positive, a bit like if you're an athlete or something, and they're building you up rather than
Yeah.
knocking you down. And so I thought, well, I've been here before, where a solicitor or a barrister have suggested, not to me, but to a company that we were managing, you know, or involved with, charge, plead guilty. But here we thought, here we go. They're going to say plead guilty, a bit like the post office said to the 700 sub postmasters who since been found to be wrongfully accused. And sure enough, they were saying, well, look, the barrister said, look, it will be tens of thousands for me to defend you. I recommend, Mr. Ottely, that you plead guilty. And the solicitor the same. And in myself, by addressing what I would call, away from the legalese, the the language problem that seems to happen in the way legislation is framed, away from that, in my inner conscience, thought, well, there's nothing wrong here. There hasn't been
Mm.
a fire. There is a fire risk assessment. Whether it's sufficient and suitable and sufficient is a matter of opinion. We have done everything we can with this cladding problem, which it turned out would cost 1.5 million to put right. So you either charge the owners, there were 50 of them, 30,000 each immediately, or you wait for government funding, which was in the offing. As it turns out, on that story, we've now got the government funding. The leaseholders haven't had to pay waking watch fees. They've had normal levels of service charge. So it's a fantastic success story for the owners. We're about to move forward there. But from a legal point of view, it seems to get very bogged down. And I suppose the fire service as well, with their need to prosecute after the black marks against them at Grenville and
Yes.
the way they told people to stay in their flats, even though really they should have evacuated. So there we are. On the one hand, no complaints at all at the building, no victims, in other words, which is what
Right.
crime should be, really. There should be victims. Also,
Yes.
no fire. So when you think about it in your conscience, as you'd imagine an ordinary person would, away from the language, they think, well, but nothing's happened.
Right.
Everyone's perfectly safe. And after the summons had been brought, we actually did a survey that we were able to do under a new sort of management method that had just been brought out, and it said yes, everything's actually fine at the building, apart from, yes, you need to replace the cladding.
So, can
So
can I just? I don't mean to interrupt because I'd much rather you told the story. But you mentioned that your company and yourself personally were being summoned to or prosecuted.
yes.
Why? Now I don't know. Running a company, what that would mean. Why would they go after you personally? Is that to make you personally liable?
um yeah, essentially yes, because so I found that quite well, rather below the belt, if I'm, making me
Yes.
personal, because we've got employees, but I realise as the captain of the ship, as I put it that way, then yes, you are liable for what your company is involved with.
Right.
So a managing agent, there is a lot of responsibility. But innately, I felt that I'd done nothing wrong. And luckily, at this stage, I'd come across trial by jury and the activities of lawful rather than legal, which I know you've been
Yes.
into with various interviews and explored that topic. And certainly, it's a very real situation in that the legal, of course, is put together in Parliament, and quite often MPs don't seem to be in the chamber to actually vote this legislation through.
No.
I noticed even with fire safety legislation that in the 1970s that it was a fine for, now it's imprisonment. So
Gosh.
before you know it, it seems that every time Parliament sits, and a new government particularly, there seems to be more legislation that it seems to be becoming more draconian. And also, the language used means that you're getting further away from the idea of a crime, which is, has there been any harm, injury, or loss? Has there been a victim? A bit like if you put a mouse in a box, um, went away, came back into the room with a cat, put a cat in the box, went away, came back, and then you opened the box and there was no mouse after taking the cat out. They'd probably then proven beyond reasonable doubt that the cat did it, as it
Mm,
were. But of course,
absolutely.
if at closer inspection you see a hole in the box, then there's
Yes.
reasonable doubt. And you'd hope that also a jury, and that's the idea of the jury, that you know you've got to, it's got to be beyond reasonable doubt, and also you've got to be you're not guilty until proven guilty.
Right.
But it does seem with our system, particularly if you go in on the solicitor and barrister's advice, that somehow you're guilty just because you've been prosecuted or someone's been brought against you, then unfortunately, if you feel within yourself that a crime has not been committed, or indeed actually a crime hasn't, it's black and white, that a crime hasn't been committed, then you should not be coerced into feeling that you've got to plead guilty. And it seems that about 86% of cases do plead guilty. So you're left with 2% of cases, which is a woefully small number, who actually go to court in front of a jury.
Right.
So it's important that you uphold your rights. Obviously, if you know you did it, a bit like Colonel Cuthbertson in the conservatory or whatever,
Yes.
then you possibly would, you'd plead guilty. But most cases aren't in that order, as we see in the papers. There are so many grey areas, and people, by the looks of it, wrongfully um, found guilty, or maybe they just want to, they can't. There's a lot of psychology involved. Also, you might have a family you're looking after. You may be pregnant. You may have elderly parents that you're looking at. So there may be all sorts of factors why you plead guilty. But
Right.
unfortunately, it doesn't do our justice system any good, nor you any good. It may seem, an easy option, but unfortunately, you end up with a criminal record and all the problems you may have with that. So it's so important. But then people may say, well, hang on a minute, but how do we afford this? Or how do we persuade a solicitor and a barrister to go along with this? And unfortunately, the legal system, you then, and what I'm saying is what I did. So I'm not,
Mm.
got to be careful. This isn't sort of legal advice in any way. This is independent, cold face situation that I did, and to get in front of a jury. So I decided to break away from my solicitor and barrister, um, thinking, well, hang on, I can't afford tens of thousands. That is a big problem for people.
Yes. So just before you tell us what you did, just to
Mm.
quickly recap, then there you are looking after a building.
Yeah,
There's a regulatory rule or guide, well, a rule, I suppose, or a piece of legalese that said something about the cladding needed to be done, or
yeah,
whatever.
yes,
And by not doing this ordinarily in a world that you and I would prefer to live in, and not the one that we found ourselves in, somebody may say you need to do this, and if you don't do it, there's a penalty, like a fine, and it would be a simple thing as that. But for some reason, the fire brigade, or the fire, whatever you call them, decided that they wanted to make a bit more of a thing out of this and to take you to a private prosecution. Is that
yes.
effectively where we are?
Yeah, they wanted to make an example
Right.
of us. I have gone into a bit of detail, but I don't want to go into too much detail into
No,
the
no.
case itself. But that's exactly it.
Yeah.
And you could say, let's all be team players. let's, and this is what in life really, that's what a jury is. It's
Yes.
community. Let's be, instead of adversaries, which I feel is so often the case, certainly in the um, court case, the legal profession, also in the inspectorate, in this case, the fire service, instead of really telling us, and they could have been let us know, communicated far better what they wanted to do, but didn't,
But didn't.
and then turn very adversarial. So really, if we're all team players trying to build our communities, listen to people, be also listen to a scenario where, hang on, can someone summon up 1.5 million? Let's be practical.
Yes.
Let's look at mitigating circumstances, look at timescales. So there we are. Yeah. So we found ourselves, although I tried to stop this case because no one really wants to be in front of a court, but
No.
writing letters and all the usual things. But sure enough, we found ourselves on our way, and so I dispensed with the solicitor and the barrister, and went at it myself with some advice from a common law perspective, and reading around the subject myself, as to how you might apply yourself. Because now we mentioned about lawful and legal. Really, yeah, that's a whole subject in itself.
Yes.
No, but even if you don't get involved in the minutiae of that, you really got to accept that in the legal and legislation, language, all they're really trying to do is catch you out on language.
Yes.
They want to frame you as somebody in a word or more than one word, and then they can that match it up with the legislation, and the sentencing is already defined in the legislation and in their protocols as well. They have a sort of chart or a flow chart of, what they believe your sentence should be. So
Yes.
what I've found out along the way is, having had this experience as well, and now been on the inside of this, talking to professionals who've worked in the service, shall I put it that way, outside the legal side, but in um, sort of the criminal justice system, and also can now relate to others who've been on in a jury. And really, certainly the people I spoke to within the justice system, is that people are going to realise there are no mitigating circumstances. As far as the legal is concerned, and if you guard it in the standard way in front of a judge, you're guilty before the fact that you've even got a summons is you're guilty. You've got to
Yes.
realise that if there isn't proven guilty, that they're already on their way. They want to prosecute. They want you to be criminalised,
Yes.
sentenced as quickly as possible. So
So, so yeah. So, just to move it along, then. So, I mean, normally, as you said, you'd go in front of the magistrate to begin with. So, what did you do then to
yes,
manage to get to trial by jury?
yeah. So what you do, you've got to go against your ordinary instincts. It depends on the person. Most of us
Yes.
are used to being helpful, answering questions, and trying to empathise with people. But what you've got to do, especially, and it's right through the Crown Court, but particularly in the Magistrates Court, because they're volunteers, and it's the clerk of the court who really make a decision. They're not legally trained. But
No.
then, so you go in front of them, and they say, "Is your name?" And you've heard this on your program
Yes.
before, and I'm not saying I invented this. I, um, you know, got in touch within the common law sphere and was given words to say. And so I thought, right, I'll test this out. So went in front and said, what's your name? And I said, I'm commonly known as. What's your database? I don't know. So in effect, you're being unhelpful,
Yes.
which goes against the grain.
Yeah, it does.
because it goes against all your thinking, really. You're the opposite. And then
But also you are being truthful, aren't you? I mean, I had a guest on the other day, just to make this point, had a guest on the other day who said, when you're writing the date, you can't prove that. I mean, we're recording this on the 18th of September. I can't prove it's the 18th of September. It's just a concept that we've made, but it's just you can't prove it is. I mean, somebody's made it up at the end of the day, and so you're being truthful. You weren't there at your you were there at your birth, but you weren't physically aware, and because you were barely conscious at that point. Blimey, there's the world. And so you are being truthful. You say, well, I don't really know when I was born. It's all hearsay, isn't it?
you're absolutely right. And, you'd hope your mother would know, but even they are sort of quite out of it. But the point is, as you say, you yourself have got no understanding other than at some point when you are conscious, older, you know that you've got a birth certificate. And I realise that's something separate as well, from a legal and lawful point of view. But you're right. So you're not being untruthful if you don't know. You yourself aren't conscious. You weren't conscious of it.
Yes.
You're just being told in the same way as the news. You're being told in the news about something. Whether it's true or not is another matter. So yeah. So and then they'll try and get you to, how do you plead, Mr. Ottely? Do you plead guilty? And you just say, I don't understand. I require a trial by jury. Because, in other words, you don't stand under the court.
Right.
And it's true, again, you don't want to put yourself under a volunteer sort of magistrate,
No.
somebody who's not trained. So why would you? It's like going for surgery at the hospital
Well,
and
yes,
and
exactly.
and willingly, you know, get
The
involved
road
with this.
sweeper out there,
Yeah,
on
exactly.
my
So,
part-time job, I just come in at weekends and just chop people up a bit. And sometimes I'm good, and sometimes, mostly, I'm rubbish at it. So
exactly.
yeah,
So it's quite understandable that you might try everything to get out of the place as quickly as possible,
absolutely.
intact. And so they do scratch their heads because this is unusual.
Yes,
I don't understand. I require a trial by jury. They'll So there, that went on. You said a few times, and in the end, they do scratch their heads and say, "Well, you're free to go, Mr. Otley." And it's important to I leave at my own
yeah,
volition, because you're standing in your own
yes,
sovereignty, if that's the right word. You're not under them, so you then leave. I think in my case, the clerk got confused, and suggested that I should be on £40,000 bail or something. But luckily, the barrister of the fire service, who was helpful on this occasion, said, "Well, of course not. Mr. Otley is going to reappear. It's not that kind of offence." So you could see the sort of confusion. If the magistrates were given more powers, and hopefully they won't be. I heard in the news, more saying we could end up with life imprisonment without some complete misunderstanding.
absolutely. And this is why this is so important that these things are highlighted so that people can go and demand this trial by jury.
Yes.
Of members of the community, their peers, etc., rather than the corrupt system getting more and more corrupt and fraudulent. So, how did you feel? I mean, you said that you were told these words to say,
Mm.
and you were in for a penny, in for a pound. At the end of that, I mean, your confidence must have been boosted.
Oh, definitely. Yes. There's no doubt about it. It's very psychological, particularly the waiting for the magistrates court. Each hearing, it's very psychological. So it isn't a free ride in any
Right.
way. It's not a case of, breezing in. There is immense psychology. But
Yes.
once you achieve it, yeah, you come out and you think, wow, I feel good about myself. I feel, yeah, I did feel elevated. I certainly didn't feel downcast. I felt elevated, upbeat. You feel like your voice has been heard, which of course with a
Yes.
magistrate and a barrister it isn't. You're there defending yourself. So you come away, and I felt very good about it. And
Having saved
then
tens of thousands of pounds from having a barrister representing you.
exactly, so you've saved all that money, and you've come away, and you feel that you've upheld principles as well. You've
Yes.
felt in yourself nothing, you've done nothing wrong. So we're en route to this trial by jury.
Right. So
Um,
what happens next then?
so what happens next is of course, it goes to the Crown Court, because mine would have gone anyway, being an individual that, from a sentencing point of view, the regulatory sentencing is 2 years up to 2 years imprisonment, and an unlimited fine. Um, so you you then go to the Crown Court, and again you don't do anything differently there, but you are faced. It's immense psychology.
Mm.
It's a theatre. It's tactics. Everyone is extraordinarily theatrical. If that makes you feel, it might make you feel better. At some point, yeah, you've got to really try and relax your mind, but also see through things if possible, see the theatre of it,
Mm.
see how the judge almost runs the court in a very up tempo and then down tempo, feigns this sort of mood and then moves into another kind of mood, um, all to really fool you, really. And then they might, on purpose, as I heard, they didn't do this to me, but someone else said, who recounted a recent hearing, they might call you a different name. Oh,
Right.
Michael Robson, and then you'll call out, well, my name isn't Mike, and of course you're then involved.
Yes.
So you've got to stay out of the language. So they may throw a curveball at you. In one of my hearings, someone, the clerk of the court, actually asked me my name, unexpectedly. So they'll do unexpected things. But essentially, you're doing the same thing. I require a trial to a jury. I don't understand. Um, Also, I remain standing because the judge comes, you're meant to sit down and then stand up. But again, there's psychology. The clerk will look at you with a stern face and make hand signals to sit down. So you're faced with sort of body language, everything there to make you feel uncomfortable. But I stood up, and then you're told, well, you're in the prosecution's area of the court. But then in another hearing, I was, it was clear that because I was in the same courtroom, each time, it's not the prosecution's area anymore. So you can tell that was a
Yes. They're
ruse.
trying to get jurisdiction, aren't they, by making you move as they've
Get
given you an
just
order.
yes, and then my mental health was, sort of, they say, oh, we're not sure you're fit to plead, Mr. Ottely. So, they're getting at your mental health. We'll have to call some psychiatrists in immediately.
Oh gosh.
Um, so there's every kind of route,
Yes.
but you have to face it. Once you faced it, it suddenly goes away.
So when they said that your mental capacity is in question, and we're going to get some psychoanalysts in or whatever, presumably they want you to react to that by saying, no, no, I'm perfectly in sound mind or whatever. But you say nothing. Is that right?
That's right. You just say, I require a try. I don't understand. I require
Yeah.
a trial by, or I hear your words, but I require a trial by jury.
Yes.
They'll also, in another hearing, just to give you a full toolbox here of language, I'm sure there's more language other people can use, but this is what I used. And well, I'm jumping ahead slightly, but what tends to happen is, of course, they got nowhere in the first hearing, as far as they're concerned, because they want to trap you. They want
Yes.
you to sign here. You're guilty, Mr. Otley, aren't you? Here we go. Let's get this out of the way as quickly as possible. But when they don't do that, of course, they've then got to have a further management hearing, as they call it, or some other case management hearing. So it's then booked, I think, for a month later. So then you go in again, you have to sit in outside the court. And of course, there are posters on the wall in the court even saying, well, if you admit guilt, we'll give you a third off your
Yeah.
sentence. It's a sort of
Yeah.
like a special offer, bonus sort of thing. And
Yeah.
you're faced with that. And of course, there's that sort of psychology. You've already gone through the security in the court where you feel a bit
Mm.
criminalized anyway, because they've got their, X-ray or whatever they do, the magnetic stuff, you have to empty your pockets. So you've had all this. But you then go back in, and of course, the judge may then not be there. So you're then left standing. You wonder what to do. So that's another tactic. The judge then appears and says, "Oh, I've got an important phone call," and then disappears again behind this curtain. And so it's all there to, you think it's real. And then another favourite tactic is handing you, well, I'm going to write this out, Mr. Ottely, when you've got to attend your next hearing. And if you don't attend, Mr. Ottely, you'll have absconded and we'll have to arrest you. So there's all this sort of stuff. I want you to take this piece of paper, Mr. Ottely, and he gives it to the clerk, and the clerk approaches me with this piece of paper. And I said, you could either, I don't understand, I require a trial by jury, or another, if you're trying to be comical, just to break the monotony. Although I don't want to be flippant on this. This is a
No.
very serious
Yes.
psychological thing. But I'm saying I'm unable to accept such a lovely gift. Uh,
Excellent.
so then, of course, actually, the judge rather liked that one, and sort of had a bit of a chuckle. But again, with the judge, you never know whether they're on your side or not. It's all,
Mm.
yeah. So really, we had a number of hearings because they weren't getting anywhere. And but at about the third hearing in, they booked the trial by jury for a year later. So people have got to realise that there's waiting. It's psychological, all this waiting.
Yes.
It's hanging over you. It's
So they
not.
book. So they book you a year hence for this trial by jury. In the meantime, then you're free to go about your business, and but you've still got this hanging over you, and
Yes.
presumably there's press coverage. If you're local press, and so it's going to affect your business because
Mm.
there's this constant, and what the press are like. Oh yes, criminal cladding,
Exactly.
Grenfell,
Yeah.
all of that, which adds to the worry, presumably.
Oh, yes, it was very bad press. Oh, yeah, they run you down as you'd imagine the journalist
Yes.
would. It's
Well, bad
um,
news always sells, so they're not going to put good news and say this poor innocent man is going to court for a simple
sick,
regulation thing, and they're treating him. They're not going to say that, are they?
not at all. So, but interestingly, at the end of the case, I did managed to engineer some good press. But I think, and I could get onto that in a bit, but I think that's by being truthful, true to yourself. Whatever happens, it's important to be true to yourself, to keep follow through, because once you're in the system, you could have pleaded guilty to have an easy ride, but where does that get you?
Well, exactly.
So you've got nothing to lose once you're in the system. Represent yourself, because solicitors and barristers, as we know, are part of the system. Um, and so we're moving along with these hearings, and although it was booked for a year, they were still trying to trick me. And they said, "Oh, we'll have to move it from the court we're in. We believe, we'll have to go up to King's Lynn, which is some way off. A
Mm,
Nightingale course, it was mentioned, or we'll have to go to this other town." So they were always looking for a reaction. You might say, well, "Why? I can't travel up there. What's all this
mm.
about?" So always looking for reaction. Another hearing, I actually ended up in the hearing with another person. Plus, on the as we were waiting in the hearing, there was on-screen stuff going on with the judge where there was someone in prison and two barristers all arguing, well, not arguing, but discussing when this person will be allowed to appeal or come to court, and holiday provision, and everyone was on holiday apparently. So it was very upping the fear factor again. It's all about
Yes.
fear and control. Oh, I could end up in prison. Oh dear.
Yes.
It's that
Yes.
kind of thing. Obviously, nothing to do with a regulatory offence, I wouldn't have thought.
No.
Don't know
But
what the
as you say,
offence
it's
was,
it's
but
there to get you to be worried and yeah.
yeah, so there was all this worry that they put your way. In my case, we don't know, everyone's going to be different, but in
Mm.
the end, I had 11 hearings
My goodness.
because they were
That's
trying to
you
get
loved it
me.
so much.
Yeah. And then at the very end, of course, another trick was it was booked for that date. And so we're getting close to the year up. And in the latter part of that year, I seem to be in court every, a couple of times every 3 weeks or something.
And
Uh,
if you didn't attend, if you weren't able to attend, would that go? That would presumably go against you because they would judge in your absence. Is that right?
yes, they would. You could have a very good reason not to attend, but
Yes.
it. What happened in my case, it was booked for this date, but then in the very last hearing, with a couple of weeks to go, the judge said, "I've changed the date to a week later." You
Right.
said, well, hang on a minute. You're thinking to yourself, well, I booked my witnesses, because if you're defending yourself, you arrange your own witnesses, defense witnesses, and the prosecution have got their witnesses that they've let you know about. Another important thing is not to give away your defense. What they would love you to do is email them with everything that you're going to do at your trial. It's
Oh,
a game of
right.
chess, this,
So they know your trump cards in advance.
exactly. So you mustn't do that. So my defence statement was purely, I've sent them a defence statement, which you're meant to do. I require a trial by jury. I'm innocent until proven guilty and require a trial by jury. That was the defence statement. But everyone gets a bit hot under the collar with that as well.
Mm.
You go through this stuff, but by rearranging, so that's another trick, really. Also, it
Oh, I've
happened.
heard. I mean, we've heard on the show people. They'll book you, say, 2 3 months. Sorry, 2 or 3 weeks, and then they cancel it and make it almost the day that the letter arrives, so that there's no way you can actually attend. I think that
That
happened to Mick,
oh,
one of my contributors, and it's like, oh, you're changing the rules as you go.
actually, that did happen to one of the hearings. One of the
There you go.
hearings, I didn't get any paperwork. It was just pure luck that that I got to hear about this hearing. So it did happen on one of them. So
There
they
you
have
go.
tried everything. And then, yeah, so you got so you got yeah, so they moved it a week, and so I did try for adjournment. Basically, my mother-in-law had died 2 weeks previously, so we'd arranged her funeral to come after the trial,
Yes.
of course, and also a main witness of mine. Not that they would know that at that time, but wouldn't have been able to do the days that required that he was going on holiday by moving that at the trial. So they messed up my schedule, and in the end, I tried to get an adjournment, but they wouldn't listen to the fact that I got a funeral. So we then had to go for this trial a week later. Also, it's not before me, it's before another judge. Oh, right. And we're not in this courtroom, we're in another courtroom. So you'll have to travel to this other town. So they mix it up as much as possible. So then we arrive in the other town. I was given a day off to attend my mother-in-law's funeral. which was in the week of my defence. So again, it cuts down your defence time, really. If you, but the point is, we ended up in front of a jury, and 12 people. They were sworn in. Um, so there we are. So after all that, psychology and sort of tactics, you're in front of a jury.
So was this it was a trial by jury as opposed to the jury trial that they often try to
Right.
get you?
This is where we've now analysed this a bit further, Richard. We're in front of a jury of 12 people, so sure enough, you're in the court. And what is immediately realizing is you're now in another, but it's almost like a video game or something. You've gone through the first levels, you're now in another level of this trial, as
Theatre,
we call it,
yeah.
where you're now faced with a situation where you've got a highly professional barrister on their side. You've got your prosecutors there as well, sitting in a line and in the audience. Well, not the audience, the gallery.
Yeah.
You've got your judge and 12 members of the jury. And what happens, you realise that as you get going, that the barrister really has, and why wouldn't he? You're professional, is his witnesses have been coached to an absolute, as if they were in a theatre. Their
Yes.
lines are learnt.
Yes.
You know, and that was found because I then was acting as my own barrister, of course. So I was doing the cross examination, and
Gosh.
you could tell when you cross examine that they were totally different personalities quite often than the coached one. But you can't help realise that they're coached.
No.
Also, the barrister will try everything to, let's face it, he is being paid by the local authority. Everyone's part of in court, and his job seems to be to get a guilty verdict. That's his job. It seems that from my observation of it, is it's not their job to prove that prove
Guilty or innocent. Yeah.
innocence. It's to look, we're prosecuting him, we're desperate. He's guilty.
Yes.
We just got to trap him, just do something here. So it's very much a feeling of you're guilty. It's just how are we going to trap you this time, or how are we going to do it?
At this stage in the trial by jury part, are you now able to say who you are, or how are you addressing yourself?
Yeah. So it's important. You're riding two horses really at this stage. You this is because trial by jury. Let's face it. It's hundreds of really. It's been so superseded by people pleading guilty, 86% or something like that, and now only 2% in front of a jury. That since the days of where trial by jury was commonplace, and let's say we're talking over 100 years or so ago that really
Yeah.
it's happening on big scale. It's been whittled down really every decade, really. Although the judiciary are still very high up, are very, if you hear a lecture, it's very important to stop authoritarianism legislation, because if you keep legislating in Parliament, it gets worse and worse.
Yes.
As a trial by jury, the idea is that the members of the jury say, well, hang on a minute, this legislation isn't fit for purpose,
Right.
or whatever. But anyway, back to the courtroom, they're not interested in that. They're interested, they've got a job to do. We've got statistics to uphold. We've got headlines
Yes.
to write. We've got a fire service to keep happy. They've got to find a guilty verdict. So there's all this stuff
So,
going on.
so did you? Sorry, just to go back to that question. Did
Oh yeah.
you? Did you say? I am. Can you
Oh yeah.
now say I am the
So
person that you?
yes, so I did at this stage. I'm in front of a jury, so I'm happy. I've got what I wanted.
Yeah.
So it's not a case of I don't understand anymore.
Right.
I asked for a jury, I've got a jury.
Yes.
So yes, I am Edward Ottely in front of your jury. There we go. So then, but what we've got to realize then is you've got a jury, but you've somehow got to make it a trial by jury.
Yes. So
Yeah,
I mean, is it classed as is it classed as a trial by jury, or is it classed as a jury trial?
right. That is, as far as my hearings were concerned, we always use the term trial by jury because that's
Right.
what I wanted. And a
Yeah.
trial by jury is they judge the facts, the
Yes.
evidence, and the law. Now, in reality, the judge, this is where you've got your opponent, the judge will always want it to be a jury trial.
Right.
So
Yeah.
even
Of
though
course.
it's labeled as a trial by jury, the judge will always fight back and want it to be a jury trial.
So, are you able to remind the jury? I mean, often when you see things like Rumpole of the Bailey
Yeah.
and that sort of thing from, decades ago now, are you able to address the jury when you're defending yourself and say, ladies and gentlemen, members of the jury, just to remind you, this is a trial by jury. You have got to listen to my points of view and see whether you believe that I am innocent or guilty of the bits that I've got here, and that it is not a jury trial, so that the judge is going to define the outcome. It is down to you, ladies. Are you able to do that sort of thing?
Yes.
Oh,
Um,
brilliant.
because being defending yourself, and again, it's about not everyone wants to necessarily stand. So I realise there are impediments to this, but
Yes, of
it's
course.
important. Doesn't and the language is not important. You don't have to use technical language; just use everyday language. But you're
Yes.
right. So you are judged. That's the whole point of trial by jury: is you judge them with everyday language. Look, I'm an ordinary man or woman.
Yeah.
Here I stand before you. You know what you've got to do is go beyond the words that you're faced with, suitable and sufficient, effective, neglect, all the sort of things that they use, and say, well, has a crime, what we're trying to do here is, has a crime been committed? Has there been any harm, injury, or loss? Has there been a victim? In your own opinion, in your own conscience, does this man before you is did he act as a criminal would? In other words, was this planned? Um, are there mitigating circumstances? You know, the time scale of this. What sort of building is it? What in this case? So you bring in all the mitigate, all the stuff that But the point is, at the end of the day, you're appealing to the jury to look at their consciences. And this is where it does come back to the Ten Commandments: "Thou shalt not steal, kill, bear false witness, etc." You've got to tell the truth. Is this person being truthful? So it's almost and every day the idea of the jury is it takes it away from this technical language and keeps it in the everyday, so no one is outside
And so
by
this must be very empowering once you've got to that point and you're able now freely to be able to express yourself and look the jury in the eye and say all those things about the case so that they will go away and come to a point. I mean, the empowering, having 11 hearings, the relief to be in that situation. How did you do? Would you find that easy now to do, to talk to the jury?
well, obviously I was going into this never having done it before.
Sure.
And in a way, so although I sort of looked up videos of courts and tried to talk to people, overall, the actual when do you do your opening statement? When should you do that? I've got overall an idea. Um, But yeah, I knew there was an opening statement. I knew there was a closing statement. I knew that that there would be the barrister, cross-examining or examining. He's called examining. The barrister would examine his own witnesses, and then I'd cross-examine them. So it's empowering that you can then ask the questions of his witnesses. So you're in a power, and then in talking to the jury, yes, it's very empowered. You're able to do that,
Yes.
and of course, I suspect where we are is that because it's early days, I would say, with trial by jury, is that what we've got to do is people have got to get away from the plea bargaining, the examine their consciences and say, well, has a crime been committed?
Yes,
Okay,
absolutely.
and then also I think with the jury, they would then hear of a neighbour because we're all potentially going to be on jury service, so it's important that we all take up that jury service, and the more courts with juries, the more people will be involved, and of course, when you get involved, you then get used to examining your conscience, get used to moving on from getting trapped in legislation, the language of
Yes.
legislation. So, people get more and more familiar, whereas there is, I would say, in my case, that you could tell that the jury were very much in awe of the judge.
Were they? Oh, that's interesting. So
Yeah.
tell us what. I mean, we're running out of time, but so
Okay.
tell us what happened in the end. So you've
Yeah.
spoken and you've done that and you've cross-examined and all of that, and ultimately the jury have to go away
Yeah.
and make a decision.
Yeah. So what I would say, and every case is going to be different. I'm bringing my case in. The judge will, whether you like it or not, try and say, well, no, I'm in charge of the law. So where we are with this is that I did the closing statement, summed up, and said, now, as I said, it's now your conscience has a crime been committed, um, and but the judge uh, did a closing statement, a
Mm.
summing up, um, and that was very much in favour of the prosecution,
Yes.
all their experts and that sort of thing. So, what I would say in my own mitigation, and I'm not expecting anyone to agree with me, they might say, well, hang on a minute, this
Mm.
chap, what's he talking about? I am involved in my case, and I'll always um, say, well, within myself, I feel that we were correct in everything we did.
Yes.
But what happened with this jury, although we had a judge who was fighting back all the time, and I could go into running out of time, and we could go into even more detail, but
Sure.
one thing, obviously, we don't know when the jury go into the jury room because they retire. This went on for 2 weeks, by the way. Um, so when the jury then retired, we don't know quite what's said, but what's meant to happen, and this is democracy in action, true democracy, is if one of them is unhappy, then case dismissed, as it were. So you don't have to have majority verdicts. That's where a jury is so important from a democracy point of view.
Right.
Yeah. But in my case, got to say that they came back. I had 5 charges, and on one of the charges, they dismissed it. The others found guilty on,
Oh, did they? Oh, right.
4 out of 5. Now, I'm bound to say that I feel that it was an uphill struggle, with a judge intent on doing what he had to do. And also, but I would say that it's really important. I'd rather go through it, become empowered
Yes.
to the jury, um, have it, because what else is there?
Well,
I
no.
plead guilty at the
So
start.
just to sort of sum up then? So the jury went away and they came back and they said, okay, on this count that you're innocent, but on these other four charges we find you guilty.
Yes,
Did they do? So the judge had no say on that bit,
no.
but did the judge have the say on what the penalty was?
Well, this is interesting. This is why at the moment you're riding two horses.
Yes.
You've got to keep the judge happy, um, which I didn't find, I believe, although you never quite know whether the judge is
Sure.
happy or not. I feel by being yourself,
Mm.
talking, this is important because even if the jury is against you, well, not against you, but find you guilty of fire,
Yeah.
whatever happens, you have got your voice out there, and your voice is clear. Whether a judge is a judge, there's a humanity there at
Yes.
some level. So you by representing yourself, talking in plain language, you then, in my case, then went to a sentencing hearing.
Right. So they didn't sentence you at the time. They find
No.
you. They find you guilty on four counts. That's that day over.
Yes,
So then you go to a sentencing hearing, which no longer has the jury.
that's right. Now, in a proper trial by jury,
The jury ought
um,
to do it.
they should do the sentencing.
Yes.
But this is why I said we're pushing, we're moving along, and but the more juries you have, the better it'll be for everyone.
Right. And
Um,
so in the sentencing thing, you're there basically facing what a panel or a judge who just
you're
who just
facing a judge and the barrister of the prosecution.
yeah.
But I myself gave another full, what's the word, um, representation of myself,
Yes.
represented myself fully. I called in written witness statements of people backing character references. I
So,
referred,
oh, I see. So that can make a difference, can it? I mean,
yeah,
it's not like come to the conclusion. You just turn up and they say, right, okay, it's 20 years in HM Slade prison, whatever it is,
yes.
doing porridge. You can still sway the judge a little bit
Well, it's hard to know whether you're swaying them or not.
or
But
not.
if you again make your voice heard,
Yes.
have character witnesses, um,
Yes.
and written out. I didn't. They didn't attend court, but they've written a page
Right.
or half a page. Also, you know, at this stage, you've got a probation service involved, so you get a report from them, so you can comment on that.
Gosh.
So probation service is important as well because you can talk to them. And interestingly, once you're outside the adversarial part, people are there to help you.
Right.
Interestingly.
So
Um,
what? Just I have to bring this to a close, unfortunately. But what? So what was the sentence then?
well, essentially, it was a suspended sentence, um, and community service as
So
well,
no. Oh, right. So no money.
and a
Not the 10.
fine,
Oh,
and
and a
a fine.
fine.
There is going to be a fine, and but when I think about the tens of thousands saved with
Well,
the
I was going to say,
barrister,
hopefully it's not the same as that much.
and also the what's the word? Obviously, it's a massive psychological thing. No one
Yes.
wants it to happen to them. You don't believe it's going to happen to them. You don't feel you're that type of person, etc., etc. But once you're there, it's far better to go the full course. It's a bit like climbing a hill or something. Halfway up the hill, you might say, "Oh, blimey, I'll turn back" or whatever. Just once you're up the top, you'll learn a hell of a lot
Mm.
about yourself and about people and the system. Okay, it's not like losing at Monopoly or something. It's not like a board game or chess. There are
No.
real consequences. But if you're true to yourself, if you're always there, your voice is being heard, even if the trial by jury is always under threat. If you see what I mean.
Yes.
Um, the sentencing again just pushed forward with your voice. And there, interestingly, there was a journalist in there who was going to write this up, and she wrote in the local paper. The first part was not good, in the usual journalese, or not journalese or media, whatever they do in the media. But her second half, she heard what I said, and it came through, and she actually wrote it down.
Hmm.
And I've got to say, it must have been above the target because online it disappeared pretty quickly. So, in other words, she was in my favour. I was,
Yes.
she,
Yes.
in other words,
Constrained by our job to give the headline a bad thing, but actually,
yeah.
so there was a question there just in closing, which has now disappeared, of course. Yeah. So if you had just pleaded guilty, or if you just said, "Oh, I'm Edward Ottely," at the magistrates' court right at the very beginning, and they listened to it and they said, "Well, it's a regulatory. Here is the fine. This is what you've got to pay." Um, do you think that, I mean, apart from the length of time and everything that you've experienced and learnt from it, if you were to balance it purely on the financial side of things, um, and not taking in the time and the loss of money and
Yeah.
all of that, that it was a wiser thing, for you to go trial by jury all the way to the end, despite the fact that you were found guilty on 4 counts, than facing the magistrate and just getting whatever was likely to come to you? Do you think that, in other words, was the fine that you're going to get the same, do you think, anyway?
Oh, definitely. And also the reaction from the fire service, it's hard to read, but from what
Yeah.
I understand, they were, looking for far more. So if you just put yourself, if you take the power away from yourself just for an easy life, if that's the way of putting it,
Yeah.
I'm not saying it is necessary. You may have so many weighing responsibilities, but if, as much as possible, if you can say, no, I'm not going to go down this route, then actually the outcome, when you examine the legislation in this case, and also the impact you might have on, okay, we're there for ourselves, but helping
Yes.
others,
And
are they going to,
can you appeal?
and you could appeal. I decided not to appeal, but you can appeal. And also, you've got your conscience intact. You haven't
Yes.
sold yourself down the river.
No. Yes. And
Um,
that's very important.
yeah, you're being true, and you are, depending on your viewpoint, you're helping others because other people coming along, that authority may think again, even if the length of time involved. Also,
Absolutely. And if they didn't get the money that they were hoping to, um,
it's all subjective. I can't be certain, but
no,
the impression I get that it's always a good idea, and it's important that we really do get trial by jury back into and so
would
the more you do it, the more it is less to be
becomes a
subversive.
standard. Absolutely. Do you would you have to pay the costs of their barrister and all of that?
You do have to pay the costs, but again, you can negotiate on that, and you know, by being yourself, you've got so much more. You can get back in control.
Yes, no,
Um,
absolutely. I mean, it sounds to me. I mean, and we didn't hear all of it, but it sounds to me like they should have been a lot more lenient. But as you say, the system is so creaking on the
mm,
bias of money and getting people through it.
yeah,
But as you say, I mean, the upshot of this is that more people really should think about pushing for trial by jury, because, as you mentioned, the more we do that, we get back to a fairer system. So
yes.
if you are guilty and it's obvious that you're guilty, then the jury is going to say that. But if you're innocent and you've still got this terrible bias as we have now, the innocent are still being prosecuted, and being judged accordingly, which is not fair. So we've got to get back to a fair system. But I really appreciate your coming on and share. I know we've had to truncate it for time,
Mm,
but I think a lot of people will get a lot of inspiration out of listening to your story. And you know, let's hope you don't have to go through it again.
That's that's right. Yeah, I hope you won't. But it's very much, as I said at the end of the court case, and I'll be a bit poetic as well. It's very much a crucible. The going through court is not only a crucible for your own character and finding yourself, but also for the jury as well. So it's a very interesting process to go through, but one that we don't recommend people to do lightly. And we're not pretending it's easy or psychologically easy, but it's got to be the right thing to do.
Yes, I mean, if you're innocent and you're being um, tainted in the way that you were for
Yeah,
such a minor thing, I mean, it's absurd to plead guilty to something because
yeah,
you're just opening up the fraud further down the line.
yes.
Edward, thank you so much for joining me. Unfortunately, I have to sort of finish off, but it's been really interesting, and I'd love to know if any other people watching this have either gone down this path or attempted to get down this path, have been thwarted or have been successful in their approach. This information is definitely worth sharing to inspire others and to share those sort of stories. So the comments is a great place to put that in. Edward, I really appreciate the time, and I wish you well in everything else. You sound like a very honourable man, if I may say so.
Thank you very much, Richard. It's been a pleasure talking to you. Thank you.
Well, there we are, ladies and gentlemen. That's Edward and his story of trial by jury. Be fascinated, as I say, to hear what you do if you've had that experience or how you would handle it. In the meantime, I have to go. So it's been a pleasure to speak to you, Edward. I'll be back with more monologues and more wonderful guests. But in the meantime, from Edward and myself, thank you so much for watching. Till next time, goodbye.